Ripeness asks one question: is it too early to sue? Can federal courts decide cases about laws that haven't been enforced yet? And like every justiciability doctrine, courts use it to control which cases they hear. The classic case is Abbott Laboratories v. Gardner in 1967. The FDA issued new labeling regulations for prescription drugs. Pharmaceutical companies sued immediately. Before the FDA enforced the rules against anyone, the FDA said, "Not ripe. Wait until we actually penalize you for violating the regulation." The Supreme Court created a two-part test. First, are the issues fit for judicial decision? Is this a purely legal question, or does it depend on future facts we don't know yet? And second, how hard would it be to deny pre-enforcement review? Would waiting cause significant harm? In Abbott Labs, the legal issue was clear. The regulation was final. The requirements were definite, and companies had to decide immediately whether to comply or risk massive penalties later. The court said this is ripe. You don't have to wait for the government to punish you before challenging the law. Sounds reasonable. But watch how this plays out. In Poe v. Ullman in 1961, a Connecticut doctor wanted to prescribe contraceptives to married couples. Connecticut law banned it. He sued to challenge the law as unconstitutional. The Supreme Court said not ripe because Connecticut hadn't prosecuted anyone under this law in decades. The controversy was too hypothetical. But that's exactly the problem. The doctor didn't want to risk prosecution just to find out if a law was constitutional or not. He sued pre-enforcement to avoid that risk. The court said too early. So when's the right time? After you're arrested? Then the harm has already happened. 4 years later, the same challenge came back as Griswold v. Connecticut. Suddenly, it was ripe. What changed? The court wanted to decide it. This is the ripeness trap. Challenge a law before enforcement. Too early, not ripe. Wait until you're prosecuted. You should have brought a pre-enforcement challenge. Courts control both ends, and it's selective. Businesses challenging regulations that might cost them money, courts usually find those ripe. Can't expect businesses to risk penalties. But individuals challenging criminal laws that threaten them with prosecution, often unripe. We need an actual case or controversy. The hardness test is pure judicial discretion. How much harm from waiting is too much? Courts decide. First Amendment cases about speech restrictions, usually ripe because courts recognize chilling effects. Criminal laws that chill other behavior, wait until someone's prosecuted. Ripeness isn't about protecting courts from hypothetical disputes. It's another gatekeeping tool. Courts decide when the timing is right, and the answer depends on whether they want to hear the case.